Earlier this month, the U.S. Attorney's Office in the Southern District of New York brought insider trading charges against a former employee of OpenSea related to the trading of NFTs. Now, this is the first time that insider trading charges have been brought based on the insider trading of any digital asset. And there's been a lot of confusion about what this means. Now, I used to work in the U.S. Attorney's Office that brought these charges, and I've represented digital asset companies for nearly a decade. So I'm going to try to clear up some of that confusion by explaining the nature of these criminal charges, how they differ from criminal charges that are based on the insider trading of securities, and finally, what this means for companies and individuals that trade digital assets. OpenSea is currently the largest online marketplace for the purchase and sale of NFTs. The indictment alleges that a former employee of OpenSea took confidential information that he received through his position at OpenSea and used it to enrich himself. This former employee allegedly was responsible for selecting the NFTs that would be featured on the OpenSea website. And OpenSea kept confidential information about what NFTs were going to be featured. Once those NFTs were featured, it would cause the price of those NFTs and other NFTs that were created by the same artist that created the featured NFTs to go up. And the allegation is that this former employee would purchase NFTs that he knew were going to be featured, and then after they went up in value, he would then sell them for a profit. There are several implications of the government's theory that the purchase and sale of NFTs by this former employee of OpenSea constituted insider trading that have been widely overlooked. First of all, it's important to keep in mind that these charges were based not on securities fraud, but on wire fraud, which is a separate criminal statute. That's important because it means that it doesn't matter whether the particular token at issue is a security. It applies to any NFT, it applies to any cryptocurrency token. In fact, it can apply to digital assets that are not on a blockchain at all. Second of all, the government's theory focuses on a crime of an employee against an employer. The idea is that this employee took confidential information and used it to enrich himself, and that confidential information belonged to the employer. But the government in future cases may bring similar allegations that companies took confidential information of customers, or that service providers to platforms took confidential information from those platforms and used it to enrich themselves. And so you could see similar forms of insider trading allegations, not just against an employer, but against all forms of other contractual counterparties. Finally, this charge is a criminal charge, and we're not likely to see a huge number of criminal cases, although I wouldn't be at all surprised if we see more that follow this same blueprint. But it's quite likely that we're going to see a lot of private actions that are based on private allegations of fraud. So you could easily see class action lawsuits that are brought by owners or purchasers and sellers of NFTs against an NFT platform or against somebody else that somehow allegedly abused inside information or confidential information. And you're particularly likely to see those types of lawsuits because the transactions take place on the blockchain. So what that means is that any plaintiff's class action securities lawyer or class action lawyer that wants to try to identify instances in which there may have been some form of front running can just look at the blockchain, look at when trades occurred, and if they see a bunch of trades occurring before material information became public, they may try to use that to bring a class action in the civil context that is based on the same basic form of allegation that we saw in this criminal case. There are several things that digital asset companies can do now to reduce the risk that they would be subject to civil or criminal insider trading claims. First of all, have a clear policy about when information can be used both by the company and by company employees to engage in digital asset trading. Second, in the terms of use, clearly define the categories of information that the company is agreeing not to use. Third, comply with that policy. One of the worst things you can do is make a public statement that the company will not be using certain forms of information, and then the company uses those forms of information. Next, you want to just perform periodic checks to see whether front-running is occurring in relation to the digital assets that you use. And as I said earlier, this is something that can often be done just by looking at the blockchain. If you see a bunch of trading activity that's taking place right before information becomes public that causes the price of the digital asset to increase or decrease, there may be front-running going on in relation to that digital asset. Finally, you want to look at your agreements with any third parties that have access to your confidential information and try to ensure that there are strict limitations on how that third party can make use of the information that they receive from you. So it's not clear exactly what the scope of this area of law is going to be. We can expect to see some form of civil claims. It's likely that there are going to be increased criminal claims brought in the future. But until we see some judicial rulings, we don't know how broad these potential claims are going to be. But good news, I'm a lawyer. So if you're curious about the current insider trading cases that have been brought or steps that you can take to minimize risk to your company, feel free to give me a call. I'd be happy to talk to you.